Since long time, men were considered as the sole breadwinners of the family. However, the era of globalization has brought drastic change in status of women. All over the world, women started working in mainstream professions with equal efficiency and capability to that of the men. Nevertheless, as the influx of women enlarged in the mainstream workforce, the cases of sexual harassment at workplaces also increased. It is globally observed that 2 to 8 women out of 10 are victims of sexual harassment at workplace for at least once in their lifetime. Such cases create insecure and hostile working atmosphere for women. Sexual harassment results in violation of the fundamental right to equality of a woman under Articles 14 and 15 of the Constitution of India, and her right to life and to live with dignity under Article 21 of the Constitution, and right to practice any profession or to carry on any occupation, trade, or business, which includes a right to a safe environment free from sexual harassment. According to the latest report of National Crime Records Bureau, total 479 cases of sexual harassment at workplace were reported, out of which 82 cases were reported in Maharashtra. Despite the strong and efficient mechanism, approximately 36.3% cases are still pending before the court. Therefore, in order to protect working women from sexual harassment at their workplace, Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013 came into existence. Background: in the case of Vishakha v. State of Rajasthan, wherein, in 1992, Bhambari Devi, a Dalit woman employed with the Rural Development Program of the Government of Rajasthan, was brutally gang raped on account of her efforts to curb the then prevalent practice of child marriage. This incident revealed the hazards that working women were exposed to on a day-to-day basis and highlighted the urgency for safeguards to be implemented in this regard. Championing the cause of working women in the country, women's rights activists and lawyers filed a public interest litigation in the Supreme Court of India under the banner of Vishakha Alpviram. The Supreme Court, in this judgment, laid down certain guidelines including directing the central government to enact legislation regarding sexual harassment of women at workplace. Duty of the employer or other responsible person in workplaces and other institutions, preventive steps, criminal proceedings, disciplinary action, complaint mechanism, internal complaints committee, workers' initiative, provisions in case of third-party harassment, awareness. Who is an aggrieved woman? An aggrieved woman is, in relation to a workplace, a woman of any age, whether employed or not, who alleges to have been subjected to any act of sexual harassment by the respondent in relation to dwelling place or house. A woman of any age who is employed in such a dwelling place or house. Applicability: aggrieved woman, employee, visitor, student. POSH Act explains that aggrieved woman does not necessarily mean a woman employed therein. She might be an employee of the company, or a visitor, or a student, as well. Sexual harassment includes physical contact and advances, a demand or request for sexual favors, sexually colored remarks, showing pornography, any other unwelcomed physical, verbal, or non-verbal conduct of sexual nature. Workplace: any department, organization, undertaking, establishment, enterprise, institution, office, branch, or unit which is established, owned, controlled, or wholly, or substantially financed by funds provided directly or indirectly by the appropriate government, or the local authority, or a government company, or a corporation, or a cooperative society, hospitals, or nursing homes, any sports institute, stadium, sports complex, or competition, or games venue, whether residential, or not used for training, sports or other activities relating thereto, any private sector, organization, or a private venture, undertaking, enterprise, institution, establishment, society, trust, non-governmental organization, unit or service provider, carrying on commercial, professional, vocational, educational, industrial, entertainment, health services, or financial activities including production, supply, sale, distribution or service. Any place visited by the employee, arising out of, or during the course of employment including transportation by the employer for undertaking such journey, a dwelling place or house, Unorganized sector, in relation to a workplace, means an enterprise owned by individuals or self employed workers and engaged in the production or sale of goods or providing service of any kind whatsoever, and where the enterprise employs workers, the number of such workers is less than 10. Internal Complaints Committee, presiding officer, a woman employed at a senior level. If a woman at senior level is not available, a woman nominated from other officers or administrative units of the workplace. Members, not less than 2 members from amongst employees, at least one half of the total members, so nominated shall be women. External members, 1 member from NGOs, preferably committed to the cause of women, or who have had experience in social work, or have legal knowledge. Every employer has to set up an internal complaints committee by an order in writing. In case of different units of a corporation at different places, private sector, the committee shall be constituted at every such administrative unit. Every ICC contains a presiding officer, internal and external members of the organization. Local committees, and their necessity in at the district level, the government is required to set up a local committee to investigate and redress complaints of sexual harassment from the unorganized sector or from establishments where the internal committee has not been constituted on account of the establishment having less than 10 employees, or if the complaint is against the employer. This committee has special relevance in cases of sexual harassment of domestic workers, or where the complaint is against the employer himself or a third party who is not an employee. Local Complaints Committee has been constituted in unorganized sector, government institutions, and organizations where internal committee is not established as number of employees are less than 10, domestic work, or where the complaint is against the employer or third party who is not an employee. Composition of the local committee: chairperson, eminent women in the field of social work and committed to the cause of women. Members, 2 members, of whom at least 1 shall be a woman, to be nominated from amongst such non-governmental organizations or associations committed to the cause of women, or a person familiar with the issues relating to sexual harassment. The concerned officer dealing with the social welfare or women and child development in the district shall be a member ex officio. Local member, 1 member to be nominated from amongst the women working in block, taluka, or tehsil, or ward, or municipality in the district. At least 1 of the nominees should, preferably, have a background in law or legal knowledge. At least 1 of the nominees shall be a woman belonging to the scheduled castes, or the scheduled tribes, or the other backward classes, or minority community. Complaints mechanism: any aggrieved woman may make, in writing, a complaint of sexual harassment at workplace to the internal committee, if so constituted, in private sector, or the local committee in that district, within a period of 3 months from the date of incident, and in case of a series of incidents, within a period of 3 months from the date of last incident, and where the aggrieved woman is unable to make a complaint on account of her physical or mental incapacity, or death, or otherwise, her legal heir, or such other person as may be prescribed, may make a complaint. Every aggrieved woman is expected to submit 6 copies of the complaint, along with the supporting documents and names and addresses of the witnesses, to the Complaints Committee. The Internal Complaints Committee shall send 1 of the copies to the respondent within 7 working days. The respondent shall reply to the complaint, along with the concerned list of documents, names, and addresses of concerned witnesses, within 10 working days from receipt of such complaint. The Internal Complaints Committee shall make the inquiry in accordance with the principles of natural justice. The committee can terminate the inquiry, or can deliver ex parte decision if the complainant or respondent fails to present themselves for 3 consecutive hearings conveyed by the chairperson, provided such termination or ex parte decision may not be passed without giving a notice in writing to them at least 15 days in advance to the concerned party. Koshtak: parties are not allowed to bring in any legal practitioner to represent them in order to conduct the inquiry. Minimum 3 members are expected to be present. Conciliation: conciliation is an informal method through which parties can settle the matter before entering into formal inquiry. After a complaint of sexual harassment has been lodged, the aggrieved woman may request the internal committee IC to resolve the matter by conciliating between the parties before commencement of the inquiry proceedings. Although monetary settlement should not be made as a basis of conciliation, once the settlement has been arrived at, the IC or the local complaints committee LCC, as the case may be, shall record the settlement arrived at and thereafter provide copies of the settlement to the aggrieved woman, as well as the respondent. Where a settlement is arrived, no further inquiry shall be conducted by the internal committee or the local committee, as the case may be. Interim reliefs. During the pendency of an inquiry on a written request made by the aggrieved woman, the internal committee or the local committee, as the case may be, may recommend to the employer to transfer the aggrieved woman or the respondent to any other workplace, or grant leave to the aggrieved woman up to a period of 3 months, in addition to the leave that she is entitled to, or grant such other relief to the aggrieved woman, or may be prescribed by service rules of the company. Punishment. When all the allegations on the respondent are proved, it shall recommend to the employer or the district officer, as the case may be, to take action for sexual harassment as a misconduct in accordance with the provisions of the service rules. In the absence of the service rules, the disciplinary action, as may be prescribed, to deduct from the salary or wages of the respondent such sum as it may consider appropriate to be paid to the aggrieved woman or to her legal heirs. The employer or district officer is expected to execute such action within 60 working days after receipt of recommendation to him. Compensation. According to the Act, every aggrieved woman is entitled to compensation. This compensation shall be paid to her with regard to the following conditions: the mental trauma, pain, suffering, and emotional distress caused to the aggrieved woman, the loss in the career opportunity due to the incident of sexual harassment, medical expenses incurred by the victim for physical or psychiatric treatment, the income and financial status of the respondent, feasibility of such payment in lump sum or in installments. Malicious complaints. In case of false or frivolous complaints, the internal committee shall take disciplinary action in accordance with the service rules of the organization, can be taken against such complainant where the organization does not have service rules. The statute provides that disciplinary action, such as written apology, warning, reprimand, censure, withholding of promotion, withholding of pay, rise or increments, terminating the complainant from service, undergoing a counseling session, or carrying out community service, may be taken. The POSH Act further clarifies that the mere inability to substantiate a complaint or provide adequate proof need not mean that the complaint is false or malicious. Confidentiality. To protect the image and dignity of the aggrieved woman, the contents of the complaint, her identity and addresses, respondent, and witnesses, any information relating to conciliation and inquiry proceedings, recommendations of the internal committee or the local committee, and the action taken by the employer or the district officer under the provisions of this Act shall not be published, communicated, or made known to the public, press and media in any manner. Thank you.